Auxiliary application and appeal in the matter of Potanina and Potanin.
Yes.
May it please your lordships, your ladyship. In this matter, I, together with my learned friend Mr. Nagpal and Ms. Palmer, appear on behalf of the appellant wife and my learned friends Falk, Ms. Karen Pole and Ms. Bailey Harris appear on behalf of the respondent husband. This, as the court knows, is the remitted appeal on grounds 12 and 13. The position is that I'm going to deal with ground 13 as amended, and then in that order, Mr. Nagpal will deal with ground 12, the maintenance regulation.
Right, thank you.
The position is that it's been agreed between counsel that my aim is to finish at about 12:30. This is in view of the court's directions.
Thank you.
And Mr. Nagpal will then take us till lunch or slightly after, and then we've allied for 15 minutes in reply.
Thank you. Thank you very much.
I'll go straight to the point. The Supreme Court have obviously remitted grounds 12 and 13. And the first point I want to make, it's important that there was no criticism either by the husband or by, as I will call him, or the Supreme Court to the Court of Appeal's conclusions after 1.5 days of full argument that Mr. Justice Cohen was wrong to conclude that he'd been materially misled. It said that this is irrelevant, but we say it is important because the Court of Appeal have already concluded, having heard oral submissions and read at least some of the transcripts, that the learned judge fell into error in assessing whether, in his assessment of the written evidence. And we say also establishing that he was inconsistent in an interconnected hearing where he heard both sides and on relevant matters. Also, he made important, the Court of Appeal, particularly Lady Justice King, made important observations relevant to the reconsideration. And we say that that should eliminate any point that this court should be reluctant to interfere with any findings of fact for 4 reasons. Firstly, the learned judge heard no oral evidence. Secondly, the Supreme Court have said that the approach to the leave test should be on the basis of the wife's factual allegations, unless they are clearly without substance. And that's paragraph 92 of what Lord Leggett said in his judgment at page 292. Secondly, Mr. Justice Cohen did not give leave for my client to answer the husband's witness statement, and the reference to that is Core 370. The application for her to answer it fully was opposed. And fourthly, it is wrong, according to the skeleton of my learned friends, and I refer to paragraphs 10 and 18, pages 54 and 57, respectively, to say that the learned judge took into account on the reconsideration matters brought to his attention and omitted to be put before him at the ex parte hearing. Central to our submissions is, in fact, when you analyse, and I'll come to this, the husband's witness statement, there was nothing new said about actual connection, nothing new said about the assessment of needs, and nothing new said about the issue which we've described not as a term of law or art, lacuna. In fact, when one looks at his witness statement, he effectively accepted connection. He accepted that my client had severed her links almost entirely from Russia, except for litigation and visiting her very elderly mother, who was 99 then and has since deceased. And he did not say anything about the assessment of needs which my client had put forward. Before I get to my other points, there is an issue whether the approach of the court should be on the basis that he was exercising a discretion or an evaluative assessment. We say it was a evaluative assessment because he was assessing pursuant to the test, whether there were solid grounds to make the application, which is similar to the two cases that we've cited and are in the authorities bundle. In addition, Lord Leggett said that it was a evaluative assessment of a broad range of factors. That's at page 285 of the Supreme Court judgment. And we say the judge was exercising a similar exercise, that's double exercise, I'm sorry, to in the sprint room case. There it was whether there was unfair prejudice to the minority shareholders, and the lifestyle case where the issue was what would the average consumer conclude about the Amazon website. There weren't findings of fact. And pursuant to the test, we say, approved in the Supreme Court in lifestyle, the approach should be not only to address whether the learned judge was wrong, but to also address whether there was an identifiable flaw in the treatment of the issue to be decided, such as a gap in logic, and we say there is much that is illogical in the judgment, and a lack of consistency, and we say there is a lack of consistency because with no good reason he changed his mind between the ex parte hearing and the inter parte hearing about connection. And another factor is a failure to take account of a material factor, and we say he did not take account in his reconsideration of the lacuna point, the AA and BB case, or the injustice. And he instead based himself on findings that he made in relation to the misleading, that he shouldn't have made because he used the husband's witness statement as the factual matrix, and where many allegations in that witness statement were already concluded to be wrong.
I thought on reading both parties' submissions that actually, whether it was evaluative or discretionary, ultimately you seem to be advancing the same appellate approach,
Yes.
broadly speaking. So I wasn't sure that was an issue that was going to lead to trouble as much.
I've said a few, I'm not going to make, I finish on that
Okay.
point. But I mean, I did want to put it within lifestyle because we do say there's a gap in logic for those reasons. There's 8 points I want to make, some longer than others, and some there is an overlap. But before I do that, unless the court does not want me to deal at this stage, I wanted to say a few words about the application to admit new evidence. I mean, would now be a convenient time.
Yes, but for what purpose do you want to admit it?
Right.
Because I mean, looking at the end of the line, if the appeal is dismissed, what, on the basis of we can't find any reason to overturn the judge's decision, what relevance would the new evidence have to that at that point?
Well, it would have, we would say, some relevance before you got to that decision.
Right. If, on the other hand, we were to decide that the judge's decision was flawed and we set it aside, then obviously a decision would have to be taken as to who was going to remake it.
Yes.
Whether it was this court or the court below, and then we'd have to look at the relevance of the or admissibility of the fresh evidence for that purpose.
Yes, that is right.
So it might have different potential roles depending on what our ultimate decision is.
I accept that. But shall I just give my head? I mean, some of them without repeating. We say that.
In other words, what I'm saying is I don't think we're going to decide now whether to admit it or not, because the analysis might be different depending on what the outcome of the substantive appeal is. Yes. If that makes sense.
I accept that.
Right, okay.
But what I say to the first process, I mean, it may be, I'm only going to make the points and move on, but one of my arguments is that Mr. Justice Cohen did not apply what we say is now the lower test, which is the reverse summary judgment test, and indeed saying it is not higher than serious issue to be tried and good arguable case. So there is a slightly different test. We say it's lower. My learned friends say it's higher. So we say that the Court of Appeal, when dealing with the first question, should reconsider the new evidence, bearing in mind that the test has been refined. The next point is we do make the point that it is somewhat artificial to ignore that this court is now looking at again at a connection 6.5 years later. And obviously, some of the matters have been introduced already in an earlier skeleton without objection. We referred to the fact that the mother had died. Well, that was obviously fairly predictable in 2019. She was 99 then, but she has died. And of course, there was discussion as to what has happened to the children and their connections, if any, with Russia. And that, of course, has changed in 6.5 years. And we say in a nutshell that it is rather artificial when we criticize a finding or an observation, whatever it may be, that my client was a divorce tourist in 2019, that it is artificial not to know what's happened in the intervening 6.5 years to contradict, particularly as we had no leave to contradict what was in. We had no opportunity to say why we weren't a divorce tourist. And that is one of my major criticisms of the judgment, that that observation was made and my client never answered it. And the husband's witness statement is just full of, you came to claim you're a divorce tourist, it's completely unjustifiable, seeking almost findings to that effect, and of course he got one. And so we say it's rather artificial not to look at what's happened since. The last point is really that the Supreme Court, particularly Lord Leckett, said that the judge had to look forward, not just to disclosure, as is suggested by my learned friends, but the word is at page 285 or otherwise. And Lord Briggs said almost the same thing at page 300, to the effect that it was a provisional view. We say that this court should look forward in the extreme facts of this case. Part of the criticism that I make of Mr. Justice Cohen is that he looked backwards on connection. Secondly, he fell for the trap of the husband repeatedly saying my client was a divorce tourist. And we know early on that he was along those lines because it's common ground that he coined the phrase at the June hearing. That's accepted. And it was quite clear that he was interested in that at that hearing.
He being the judge?
The judge, yes. Yes, he coined the phrase. That's accepted. And then, of course, contrast this with Mr. Justice Moore in the case of TY and AY. He, of course, made a finding there, did exactly what the Supreme Court said, that the wife in that case was likely to remain here for the foreseeable future. And we say that's the sort of finding this judge should have made, particularly as in January 2019, he concluded that my client had largely severed her connections with Russia for a health reason, because she only visited because of her mother and because of litigation. And that is in the original judgment. Can I deal with my 8 points then?
Thank you.
The first point is that the learned judge changed his mind on connection, as indeed Lady Justice King pointed out, and the reference to that is paragraph 84 at 246 of the Court of Appeal's judgment. And this was the key point, because as I will develop...
Are you giving us the headlines now, and then you're going to expect...
number one first.
You're going to do you're going to do them in order.
Yes,
in detail.
I'm quite happy to give the headlines.
No, so
I'm still on number...
Headlines? No, okay. No, don't worry. I just wanted to know whether to ask questions or to wait. But go ahead.
I'm on number one.
Yes.
Changed his mind on connection.
Yes.
Inconsistently. And this, I was saying, was the key point in his judgment, given the rest of the section 16.2 factors were either neutral or we say positive, which is another of my points. And there was no reason to do so. And that was illogical, inconsistent, and we say wrong. And in reality, the position is that he changed his mind when there was no new evidence or reasons. And indeed, Lady Justice King referred to that about the change of mind at paragraph 84 at 246, 247. I want to deal with an observation the learned judge made at 216, paragraph 86, when he says that I accepted.
We're now looking at the judgment of
Yes,
Justice Cohen, paragraph 86. You said? Thank you.
216. Sorry.
Yes.
Where he says that I accepted weakness of my client's connection. We looked again at the transcript. That is not a fair way to describe what I said. The only discussion about weakness was when we were making the point that there was a sliding scale and connection and possible hypothetical weakness might have an impact on that. But I did not accept that my client's connection was, at the time of the hearing, weak.
Have the husband's team had the same chance to look at the transcript to confirm what you just told us?
I don't know whether that, I mean, obviously the transcript is not in the bun, but I mean, I noticed that, I have to say, only yesterday,
right,
when I was going through the judgment again. And therefore we looked, or the day before yesterday. Can I then analyse why there's no change? The starting point is page 191, paragraphs 5 and 6 of Miss Justice Cohen's ex parte judgment. Where he dealt with connection. He made no finding, as was appropriate, about my client's assertion about her health fears of being in Russia, but he noted them. And we say that was clearly relevant to the severing of connections point. It will be seen that he did not base his finding on connection on Anastasia's presence or otherwise in this jurisdiction. And all of that was for the final hearing assessment. A schedule was produced, and that's exhibited, and it's supplemental bundle 348. He asked for that schedule, and it was produced, and then it was eventually exhibited. He did not ask for us to go back any further than 2016, and he based his observations clearly in this judgment on the schedule, and of course my client's witness statement, where she dealt with connection, and the references to that, I'm not going to go to them, but it was dealt with extensively in supplemental bundle 282, and then 300 paragraphs 90 to 106. And I repeat the point that pursuant to Lord Legate's judgment, what she said in that witness statement should be assumed to be correct unless, as I put it, it was palpably wrong, including what she said about health fears being the reason not to go back to Russia. The next step was the husband's witness statement, which starts at supplemental bundle 349. And in the interest of time, I'm not going to go through it because it's quite clear what he was saying. But what's important is that he had the schedule at S346 when he made that witness statement. And the core of his witness statement was that my client came to claim, i.e. she was a divorced tourist, though he hadn't coined that expression, it was Mr. Justice Cohen. She was a forum shopper of the extreme shops type, which was the word he used, and that's at S349, supplemental bundle 349. But fundamentally, she had grotesquely misled the court. And I counted up, he used the word misled or misrepresentation 20 times in his witness statement. He made no criticism at all of the schedule, and we can discern that from page, this is all in the supplemental bundle, page 350, paragraph 7, 353, paragraph 20, and 380, paragraph 160, when he agreed with the wife that Anastasia had moved to London. So that was the position. And then at 382, paragraph 166, which is important because all he said about my client having links in Russia was that she was still registered in Russia at the Moscow apartment.
Sorry, what paragraph?
166.
166.
166. 166, I've got is page 381.
Well, I'm sorry.
You said the expression forum shopper. Where does that appear in the
349.
which paragraph? Right, paragraph 5. I assume. Answer the English stood very firmly against forum shopping means frivolous use of a favourable foreign court to gain an unfair financial advantage. This case is even worse than forum shopping. Right. Yes?
I lastly referred to page 381. 380, but I may have it wrong. Yes, I do. I'm sorry. It's 381. Your Lordship is right. That's all he said about the Moscow connection. Paragraph 166. Now, the position about my client does have a registration at that apartment, but she has not lived in that apartment since the marriage broke down in 2013. And there is another occasion where the learned judge, and we'll come to that, but I'll make the point now, where he says that she retains property in Moscow. The property, Russia. The property she retains in Moscow, in Russia, is very limited indeed. Most of it is frozen because of the litigation against her in relation to the Autumn House. That what she says was the main matrimonial home, and it is said that she owes what we say is the nominal owner of that property, millions of dollars, and that means that most of her assets in Russia were frozen. None of the property assets that she still owns in Russia were matrimonial homes, and they were of very limited value. So she had, by the time she was before Mr. Justice Cohen, she did not have an existing home in Russia. She was going back for litigation historically, but no more because it was over, and she obviously wanted to see her elderly mother, who could not leave Russia. And there was no answer at all in that witness statement to the schedule at S346. And of course, the emphasis that the husband made was on the connection of the marriage, which we've always accepted. But that's not the test. It's the connection, the present connection of the parties. And it's not just connection with England, it's connection with Russia. And if you look through the prism of 2019, there is nothing to contradict that my client had largely, if not totally, severed her connection with Russia for good reasons, and that England was her main home. And of course, we'll come to in due course the observation that the wife first bought a large property in Long Island, and then she bought a smaller property in London. The reason that she bought the property in Long Island was at the time, Vasily, the youngest child of the family, was a minor. He was going to school in Long Island near the Oyster Bay House. And after he left school, my client used it in order to see him, and Vasily used it when he went to university in Pittsburgh. And the position is that it is on the market for sale, and it is let at the moment. And one of the criticisms is that when he made observations about the contrast between buying a big house on Long Island and buying a small house in London, my client did give an explanation, which is at supplemental bundle 322.
Mr. Howard, you may have said this already, so forgive me if I've missed it, but the finding, or the apparent finding, that Mr. Justice Cohen made in the leave judgment in January, paragraph 6, that she had now very largely severed her connection with Russia. Has that ever been subsequently challenged?
No. I showed you the only paragraph where the observation was made that she had a registration.
In the husband's statement?
Yes.
But subsequently, in any of the subsequent decisions of the court, it's not been queried or said.
No, except we say, and I'll come to looking at the passage, that Mr. Justice Cohen, when he came to talk about it, started talking about her retaining property there.
Yeah, thank you.
That is all. I was referring to supplemental bundle 322 because we say his rather grudging remarks, I put it that way, about my client buying a bigger house and then in Long Island and then much later buying a small house in London. We dealt with it, supplemental bundle 322, which the judge didn't even refer to, which is paragraphs 199 to 202. Unless the court wants me to, I won't read
No, okay, yes.
read those out, but I do say that they are significant. The next development was the hearing on the 19th of June, 2019, a directions hearing. And at that hearing, you can see at core 369 the limitation to my client putting in extra evidence, which is its paragraphs 5 and 8. And that was contested. The husband resisted us putting in any further evidence, and the reference to that is supplemental bundle 71. Although my client did want to answer the witness statements. And as I've already said, Mr. Justice Cohen then coined the expression divorce tourist, and the reference to that is supplemental bundle 73. That's common ground. Now, the thrust of the 26-page skeleton for that directions hearing from the husband was that the court had been grotesquely misled and that my client was a divorce tourist. And the information about the visit to the English divorce solicitors that the husband sought was said to be relevant to that. The reference to that is supplemental bundle 69 to 70. So, as Lady Justice King dealt with in the last judgment, then Mr. Justice Cohen was not persuaded that this was irrelevant, and he ordered it to be disclosed, which it was. The next stage is the 3-day hearing. And it was put before Mr. Justice Cohen that by then, Anastasia had moved to California. And the reference to that is supplemental bundle 110. My client said this was temporary, as we say it has turned out. And as I've already indicated, Anastasia's movements were quite irrelevant to the judgment on the 19th of January 2019, but Mr. Justice Cohen, as we will see from the judgment, was interested in it as being something that had misled him. There was then 2 days of argument about whether the court had been misled, and that completely dominated the hearing. And that's one of the reasons why we say there is wrongful influence, because it is quite clear that that was the bulk of the hearing. And the case about this is what the husband said is at supplemental bundle 109 onwards.
You wanted to go to that?
Well, I just wanted to show you the heading very briefly. You can see
109.
109 in the supplemental bundle.
And this is, what's this document?
This is the part of the 49-page skeleton argument. Misled as to the reason for her connection. In truth, she came to claim any such Part 3 claim should be rejected as part of the court's opposition. So she came to claim was not only a reason why the court had been misled, but also why there should not be leave. They were rolled together.
Where is it?
You're talking about the heading.
The
at
heading.
the
So
bottom.
you're talking about the heading.
Sorry.
Sorry, yes, I've got it.
And you can see, if you go over the page, you can see 139, first line, exceptionally weak, all date, post-date the parties' separation. And then in about the fifth line, the flat is described as a token flat, which of course Mr. Justice Cohen took up when he said it was small. Then there's the Anastasia point in 139. And there was the submission at 140 that parties to the marriage is a firm pointer that the relevant connections need to have been formed during the marriage. We say that's wrong. And then 144, the English solicitor's point is made. You can see the way it was being put. But what is important, and this is what that we say is all relevant to the wrongful influence, which is my second point, and I will come to it. But however you read the 49 pages of Mr. Bishop's skeleton or the husband's witness statement, there was no challenge to the schedule, or indeed to the severing of links. Could I then take you to the judgment, because we say to, I hope, illustrate where there was inconsistency. If you could go, first of all, to page 200 in the core bundle. And you can see that my client's case is set out in paragraph 11, which starts on 199. And then in Little Roman 7 at 200, there is set out, my client obtained her cases, she obtained an investment visa, she purchased a property, and then since at least the beginning of 2017, I have lived permanently in London. And I now consider that London is my home. And underneath that, the learned judge said, each of these assertions is roundly challenged by age. Well, 7 was not challenged. And we say that starts the unfairness of this on connection. Then we go to page 200.
When you say not challenged, you mean not challenged in the... Because the statement you just showed us included that an assertion, sorry, not the statement, the skeleton you just showed us included a submission that the wife had only established connections in this country in order to pursue her claim.
Yes.
Are you saying so far as the evidence is concerned, there was no challenge to the schedule, so the assertion that the wife had lived permanently in London, and also no challenge to the and I now consider that
Yes.
London is my home?
Precisely. The challenge was the motivation, which was not a matter for the leave application or setting it aside, because that's for the final hearing. As Lady Justice King pointed out, motivation can be important. He can run his divorce tourist forum shopper point, but it wasn't open to Mr. Justice Cohen to decide it then. And when he says that the assertions in Little Roman 7 were roundly challenged, that is wrong. And that starts where we say he fell into error. Then at 207.
When you say not open, do you mean not open from a factual and legal perspective, or from a, in other words, that it's not appropriate for a judge to, I mean, there might be extreme facts, but you're saying in this case it wasn't properly open to the judge to reach conclusions as to the wife's motivation?
Yes.
Is that because that would be the sort of disputed
That's a disputed fact, which would be for the
if this was a summary, if the
it
analogy
wasn't a
is with a
matter
summary
for
judgment.
summary judgment, but it's the
Yes.
analogy. You assume the wife is correct.
Well,
but-
you don't assume that for things that are clearly
Clearly wrong.
but you say this is not in that case.
The husband didn't challenge that she permanently lived here since 2017. What he challenged was her motivation. He never said, for instance, well, actually, you were in Russia all the time, or you were in America all the time. He never addressed the schedule at Supplemental Bundle 348 to criticise it. And as I will say in due course, what the judge said about that schedule was also unfair, because he added up only the time in England. He didn't add to the holidays, because the holidays were taken from England. And if you add the holidays, my client's entitled to take holidays, the majority of her time was in England, or based in England. And the only time really she wasn't here was holidays, going to see her son in New York State, and going to Russia.
Also, at the top of page 213, paragraph 63, the judge does rightly, I think, record the fact that her husband had not challenged
Yes,
his wife has been habitually resident
yes,
at least since for the year prior to the
Yes.
application.
yes. But we say that paragraph, since your lordship has, we say that paragraph is unfair anyway, because it only counts up time actually in England. It ignores holidays from an English base, and it ignores that she had perfectly good reason to go. It doesn't mention where else she went, but she had perfectly good reasons to go to New York and Moscow. And that's why I referred the court to that passage, Supplemental Bundle 322. He doesn't refer to that. And we say this is all, if you look at paragraph 63, it's slightly grudging. And then he makes the point there, before 2015, 2016, there's no evidence she spent any significant time in England. Well, he didn't ask for that. He deliberately didn't ask for that. And my client wasn't given the opportunity to. And we make the point about this unfairness in our original skeleton for this court, which is at core 393. Sorry, core 93, beg your pardon. Going on through the judgment, the next.
Sorry, is this your second point, or
No, we're still on the
okay?
still on connection.
Right.
I'm taking you through why we say he was unfair on connection and
Okay.
inconsistent.
Sorry, unfair on connection and
Inconsistent
thank you.
and illogical. 207, paragraph 44. Much of the hearing before me has been taken up. Yes, we agree. And then for paragraph 45, he sets out their assertions. Only one of those assertions relates to connection, which is paragraph 13 on page 208. Next, 209. Under the heading, factual misrepresentation. So this is why we say, and it is partly, I won't say it again on my second point, wrongly influenced, but it's also inconsistent. He says, little Roman 2, that there was a factual misrepresentation about visiting the lawyers or consulting the lawyers. And then we say 3 is completely unfair. And this must have been carried forward. The impression given of a connection was greater than was justified. Well, there was just no basis for saying that. And on the facts of this case, and anyway, he should assume, unless there was a contradiction, that her evidence was correct. He then talks about visits to England in the past. Well, no reliance was placed on that by the judge, and that's for the final hearing. And then he deals with the daughter. And that my client had implied that it was, so he's almost making a finding there that the daughter had left England long term. Well, there was no evidence of that. How did he know that? How did he know that it was ever short term, intended to be short term, nor than it was long term? It was a development. And that, of course, wasn't even in the husband's witness statement. And we say, that's the unfairness. And then if one goes, and we say, this is all part of my second point, which I will come to in more detail about wrongly influenced, because he clearly carried this forward. 211, we say, is very important, paragraph 54. He says, if I'd been specifically asked to address those paragraphs, I'd have had more particularly in mind the following: the extent of the connection of the parties to England. Well, he did have that in mind. He asked for the schedule. And then 4, which is a point, well, I'm on it, whether wife has suffered injustice and or hardship. Well, he didn't come back to that in this second judgment. And he certainly found there was an injustice in the first judgment. Then if we could go to 212, and I'll make this point now, but it is because I wanted to follow through, because it's also relevant to connection, but it's relevant to wrongful influence. Paragraph 59, I'm in no doubt if I'd had the full picture before me on the 25th of January, I would not have granted leave. I was further satisfied, therefore, that the grant of leave was given as a result of misleading of the court, how intentional that may be. Well, we say that's another way that quite clearly he would have carried that forward into the second part of the hearing. 200.
So your submission is that paragraph 59 makes clear the judge has already said, in effect, that if he had what he describes as the full picture,
he wouldn't have granted leave.
He wouldn't have granted leave.
Yes. I mean, if this had been delivered orally, I mean, if one, as opposed to written, I mean, anyone representing the wife would have known that they weren't going to win on the second part. I mean, that's what he says.
If you go back to 54, are you coming back to 54? Because 54.2, where the judge says he would have had more particularly in mind whether or not the wife was attempting to use these proceedings as a top-up. What's he there referring to?
Well, he's referring...
The submission that was made on behalf of the husband, or...
Yes, the husband said that my client was illegitimately asking for a top-up in the words used in Agbaji. We said, no, this is not a top-up, we say, means making it an English award. We say that's not what Lord Collins meant. And anyway, we aren't seeking to challenge generosity or lack of generosity in Russian. We say there is this lacuna. But that's what he's referring to there. He's referring...
Right. Okay, thank you. Yes.
And then there's paragraph 63, which I've already looked at, which is obviously about connection, which we say is unfair. And then at the bottom, so we now go, we're now obviously in the second part of the hearing.
Yes.
And obviously these remarks are also relevant to wrongful influence. Second line, likewise, W had no significant any connection during the marriage. Well, that's not the test. You don't look to the past. And then, of course, this is on the wrongful influence point. He comes back to the advice from the London solicitors. He then says in paragraph 68, no evidential investigation. And then he makes what we say are his grudging remarks, which he was not called for, about my client purchasing the Long Island house and then buying a smaller house in London, and then that she retained pre-existing property in Russia. He does not observe that that property in Russia was not her matrimonial homes, and she deals with the fact how insignificant this property was and how it's substantially frozen at supplemental bundle 291. And you can see that he's completely latched on to what the husband says. That is, it's significant she bought this big house in Long Island, and it's a small flat in London. You will remember I pointed to you that the husband said this was a token flat. But it's not a token flat, it's my client's house, which is all, or flat, which is all she can, and he then goes, which is all that she wants to spend at the moment. And I've referred to S322. Not even referred to. And then at the end of 69, H is very dubious of the alleged health scare. Well, again, the significance of the health scare is that it's a fundamental reason not to go back to Russia. He then goes on in paragraph 70. What this does show, recent and modest. Well, recent is a comparative term. Modest is as well, but we say that's completely, you've got to look at the present. Her connection in the present was not modest, because this was the present. And that, we say, is completely inconsistent and illogical, and is only based on him minimizing the schedule, which was unjustified. And then he goes on, the party's connection with Russia was infinitely greater. Well, again, that's looking to the past. Should have looked to the present, and we say to the likely future. 216. I've already dealt with paragraph 86. 217. Well, paragraph 88 is the core paragraph, which I wanted to deal with perhaps on many points, but I'll deal with them all now. Because this is really where he draws the threads together and decides what he's going to do. And it's where he deals with the sharing claim. And he starts off, classic example. Well, that's clearly leading to a finding that my client came to claim of a spouse whose background and married life was firmly fixed, historical, and who had historical, no connection with England, seeking, after the breakdown of the marriage, to take advantage of what is a more generous approach. But we say, this is all unfair. It wasn't just generosity my client was looking for. It was to meet an injustice. And there was no call for making a finding that my client came here to seek to take advantage. That's divorce tourism. And then, of course, at the end, the game is given away. Mr. Bishop is right to say, if this is allowed to proceed, there's no limit to divorce tourism. That means she is a divorce tourist. Well, a tourist is by definition a temporary person here. And by no means was she temporary then. And a divorce tourist is someone whose motivation is to claim. And we say that that is why he got wrong. Now, my learned friends say that, well, this is a characterization of his conclusions, judicial shorthand. But it's in a paragraph where he made his conclusions and found that she came to claim. And I adopt and endorse, without repeating, what Lady Justice King said in her judgment in the last hearing. Paragraph 61 at page 241, and paragraph 67 to 73 at 242, where she dealt with the visit to the solicitor. I also, and I'm now nearly finished this point, it's my longest point, I rely on the cases which are in the bundle where there is little or no connection. There are many of them. Lockwood, both of the parties were in New Zealand. Their only connection with this country was a home here. TY and XA, well, the wife wasn't even here when she made the application. She came here. The learned judge, Mr. Justice Moore, found that she was going to stay here for the foreseeable future. A parallel with this case. And then there's the case of Al-Duki, I hope I pronounce it correctly, that Mr. Justice Moore described the couple there as slightly more than birds of passage. They came here for educational reasons, for doctors, but they never lived here. There was just a property here. So the court had to look at connection. Even when there's property here, you still have to look at connection, and that was no obstacle. And what those cases say is that you don't just look, as Mr. Justice Cohen did, and as the husband wants you to, just at connection. you look at all the relevant factors, one of which is injustice. And what we have from the husband here is an emphasis on the connection of the marriage. And that is not what the statute says.
So your summary, your two submissions are that the judge focused on connection and didn't sufficiently have regard to other material factors. And the
That's my later point. But what we say, what I now finished is my first point, is that he was inconsistent and illogical in the way he dealt with connection.
Right. And the second point, looking at paragraph 88, is picking up what my lady said earlier on. Your submission is the judge was not entitled, justified in this case, to conclude that the wife came to this country seeking to take advantage of what is a more generous approach.
And that she was therefore a divorced woman.
So, as you described it, motivation, ascribing a motivation to her.
And this is the key paragraph where he deals with the sharing claim. My second point, which I have already dealt with to some extent, is wrongful influence. I've already made 3 points about that. Number one, he carried forward the findings about the solicitor into the second half, and we can see that if you look at page 209. That little Roman 2 was, he said it was a factual misrepresentation. And then if you go to 213.
This is bound up with motivation.
Yes, but it's also why he was wrongfully influenced by his findings about misrepresentation.
Right.
Which is my second point. So if you compare page 209, little paragraph 51, little Roman 2, and then in the second part of the hearing, he comes back to it in paragraph 67 in the last sentence, at 213.
Yes.
Secondly, even though he had no reason for changing his mind about connection, he inconsistently did and carried that forward into the second part, which I think I've already given you the references on that, but it's quite clear he did. Thirdly, the finding observation that she was a divorced tourist, having coined the expression, that was only based on her going to see the solicitors. And that is still relied on by my learned friends in paragraph 19c and 22 of their skeleton in pages 58 and 59. But what we say also about wrongful influence, I mean, when a judge is hearing or conducting a hearing which is almost exclusively concentrating on him being misled, inevitably those adverse findings, and they were very adverse, are going to carry over into the next stage. So he was quite clearly, and we can see it, it's also subconscious, but it's understandable. I mean, he took a dim view of being misled, and I've already referred to the observation of paragraph 59 on page 212. He's going to carry it forward, particularly when the first part of the hearing is connected to the second part, i.e. being misled about those factors is potentially relevant.
I wonder if the straightforward focus is not on being misled as such, but a conclusion that you're misled implies that you must have reached a conclusion on a particular factual matter, such as the reasons why the wife came to England. And it's that reaching that conclusion on a disputed factual matter that's the real problem, isn't it, on your case, or should be, because applying the approach of the Supreme Court of effectively like a summary judgment, you shouldn't be making findings of that nature.
Yes.
I'm just wondering how helpful it is to talk about being misled and so on, rather than focusing on the underlying, what that must mean about the judge's view of the facts.
Well, yes, I mean, that is, I think, a more elegant way of putting it, but I mean, that is really my second point. That, I mean, his conclusions on those issues about which he said he was misled were carried forward into the second part. And that really, I mean, I use the word almost polluted the second part. And that's inevitable. I mean, this isn't like a judge who, on one occasion, concludes that an injunction isn't justified for whatever reason. Not that he's been misled, not justified, or even if he does express a view about the application. And then subsequently, something like a maintenance pending suit comes before him. And it wouldn't be the same because it'd be a completely different issue. The point I make is that these are completely interrelated. Because in the first part, he dealt with being misled about connection. He obviously assessed divorce tourism and he carried it forward into the second part. And therefore we say it's not safe to rely on the second part, which was, of course, something that, an observation that Lady Rose made to Lord Falk's, which is it? Call 327. We say that encapsulates it. And we also say the colouring it was inevitable given the presentation in what was 75 pages of skeleton argument at the two hearings from Moylan and Mr. Bishop. I mean, the whole thrust of those was not whether the test had been satisfied. The test was that the judge had been misled. And
Yes.
how the CRS, the solicitor's disclosure exposes this. And we say that led the judge to coin the expression. I mean, it was quite clear from then onwards that the judge was interested in divorce tourism, although it was argued that that was for the final hearing. And if one looks at supplemental bundles, it's quite interesting to see how the reconsideration point was put to him. That is the second part of the hearing. If one goes to supplemental bundles, at page 109,
Yes.
sorry, that was something one looked at, I do beg your pardon, 117. See, it's not till page 36 that we begin to get Mr. Bishop dealing with the second part of the test. And what he says is, and he was quite clearly inviting the court to find that it should not only set aside its order and refuse to make a fresh order at an inter-parties hearing because of the misrepresentations. I mean, that was the case put to the judge. And then paragraph 177 on the next page, the last sentence, these misrepresentations were profound and should act to set aside the leave and prevent any continuation of the proceedings. 178, if the court had been in possession of the true facts, it's impermissible to see how leave could have been granted. On the true facts, this is an unmeritorious application, as unmeritorious as can be imagined. So it was quite clearly what page 108, paragraph 180, next page, for all the reasons given above, the leave should be set aside and no leave should be granted de novo. And the position is, when actually Mr. Justice Cohen, when he gave his reasons for not granting permission to appeal, effectively said that he'd taken into account the misrepresentations. Because one sees that from core 221. These are his typed up reasons
Yes.
why he didn't give permission to appeal. The parties had, well, that's not the test. That looks to the past as opposed to the present and the future. No connection of any kind, having lived all their married life. After the breakdown, W purchased a small flat in London, which that comes from the token apartment. She engaged in very prolonged matrimonial litigation in Russia and achieved a large award. No mention of our lacuna argument, no mention of injustice. I mean, obviously, by some standards, it is a very large award, but not in the context of this case. But he doesn't mention that. I concluded that I'd not been given a full picture of the case when I granted permission, and reheard the matter which led to the conclusion, etc., etc. He therefore completely elides the two parts. And then he goes on that the absence of connection with England or Wales, or assets in the jurisdiction, combined with the extended litigation in Russia, an award paid there, makes this application an attempt to achieve a stopper. Again, no mention of lacuna. But how could he say absence of connection with England and Wales? And then we submit the game is given away in the last paragraph. I believe I applied the law properly to the facts as they were later put to me on a full inter partes basis, rather than as I understood them to be at the first hearing. So he's clearly saying I was misled. I applied those facts about which I was misled in the second part, and then I concluded. But I repeat, there was nothing new before him on either the three most important points here: connection, lacuna, or needs. And he was clearly relying on making this observation on the fact that my client had misled him, apparently, and that she was a divorce tourist. And one can see also this is the way leave was resisted. At page 109, core 109. Yeah.
Yes.
This is the 4-page reason why leave shouldn't be granted.
Yes.
And one can see straight away, paragraph 1, he was right to reject wife's claim as it was a case of divorce tourism. So rather contrary to the way it's presented now, it was just judicial shorthand. And that could only be based on the solicitor. At the end of the first paragraph, in paragraph 2, careful evaluative decision, I just highlight that.
Sorry, where's that? The very end.
The very end of the long paragraph.
Yes, was it?
Careful evaluative decision. Again, over the page, W's connections. H's case was that W came to claim. This was true and remains true. Mr. Justice Kern was told that wife had substantial connections with England. At the October hearing, he was made aware of a range of factual matters which enabled him to find that W's connection with England was both recent and modest. Well, I asked rhetorically what, because we've been through that. It was only based upon the solicitor and Anastasia, both of which were unjustifiable. And then you can see in paragraph 8, in the 2 lines up, almost giving the game away that there was wrongful influence, but this misrepresentation infected the entire application. I agree. Over the page, paragraph 13, re-grant of leave. Properly proceeded to reconsider leave afresh on the corrected factual matrix.
Sorry, which paragraph?
Sorry, paragraph 13, my lord.
Yeah.
And then 5 lines down with the full facts before him. So it's quite clearly on the wrongful influence that this is what counsel, Mr. Bishop still then, was putting to this court. And he was putting to this court, of course, the husband hadn't lost on misleading them. So the line was being put because of the misleading allegations. Then really the second part of it was almost inevitable that was going to go against. Can I deal with one or two other matters which we say led to wrongful influence? Could we look at 213?
Cool.
Core 213, yes, I'm sorry. Sorry, I've dealt with that. I wanted to look at it.
67.
No,
No?
I already dealt with it.
Okay.
I'm so sorry. I'm so sorry. His reference to AA and BB case of your lordships. It's agreed that at the ex parte hearing, I made extensive reference to that case. And the reference to that is S at 96. It's 3 pages of the transcript.
Sorry, supplementary bundle, page 96. Thank you.
It was agreed that I made extensive reference, and I think 3 pages of the transcript. I then moved on from AA and BB to Agbaji and was saying that that was also a lacuna case, which it is. The lacuna being that you could not have a transfer of property order in Nigeria. And then Mr. Justice Cohen said, I've heard enough, I'm going to grant leave. So he was obviously influenced about that. Then we come to 212. Core 212.
Yes.
Paragraph 56. He refers to AA and BB, and that's 56 is to deal with the court, Lady Justice King, or Mrs. Justice King as she then was, being misled. He then comes to 57. Mr. Bishop attacks the reasoning of this decision and draws my attention to the fact there's no reference in the judgment to the fact that the wife in that case appeared to have negligible connection with England. Well, that's a very puzzling remark because it's quite clear from the judgment that the wife in that case came to England after the divorce, after the marriage broke down, and stayed here. It's not easy to know what to take from this decision. Well, we say that's a somewhat remarkable observation. It's really very easy to know what to take here. This is a case of a lady who was not here until the breakdown of the marriage. There was no power in Slovenia to deal with non-Slovenia assets, which was an injustice, and there were no English assets. But nevertheless, your lordship gave leave. Then after this, there's no mention of AA and BB in the second part at all. He doesn't come back to it. And the Court of Appeal, Lady Justice King, and I presume your lordship, fully understood the significance of it. And there's a reference to it at 239, paragraph 53. I mean, it was the critical point in my case. And he doesn't even deal with it in the second part. So there's paragraph 53, paragraph 55, which...
Sorry, we're in the Court of Appeal decision.
We're in the Court of Appeal now. This is where Lady Justice King deals with AA and BB. So certainly the Court of Appeal understood the point I was making. Paragraph 55, we deal with it again, which is on page 239. Then at 244, Lady Justice King comes back to it. The lacuna point, paragraph 75, beginning on page 243. And she says in terms, about 5 lines up at the bottom, the judge's objection, as identified in the set-aside judgment, did not meet the lacuna point, which was not dealt with and which would have required detailed analysis in its own right. In the second part, there is no analysis. And then And then finally, paragraph 246. Page 246, paragraph 82. Second line, the judge omitted, however, as in relation to the issue of disclosure, to refer to the fact the case was and substantially remains based on alleged lacuna. And then at the end, court needed to have in mind as part of the decision making at the set-aside hearing that there were issues on which the wife. And again, we say this is an inconsistency, it's wrongful influence. Having been thought it was significant and the reason why he granted leave in January, when it comes to the second judgment, he purports not to understand it, which is incomprehensible. And then in the second part of the hearing, he doesn't deal with it at all. And finally, on the wrongful influence, could we look at page 210? Little Roman 3. I was not told the wife did not make any needs. This of course, again, is misrepresentation. So he clearly was critical of the wife about that. And that's clearly reference to his needs refusal. And it's relevant to what we call the subsection of section 16, F, the exhaustion of remedies point. And then when we go forward, 217, paragraph 89, when he deals with needs, he says, he's dealing with needs, a survey of all the other sections 16 matters count heavily against W. Well, we say what matters? There aren't any. But the only one could think of that she hadn't applied for maintenance. But as you will notice from the judgment, Lady Justice King, she didn't have the wherewithal to apply for maintenance. And that's, if you go back, go forward to C231.
Sorry, can you move the page again?
C231, paragraph 13. You can see Lady Justice King says no wherewithal to apply for alimony in Russia. So clearly we say if paragraph 89 is to mean anything, it's the judge relying upon what he was told about not making. I wanted then to turn on to my next point, which is I've touched upon, which is that the judge failed to see that the other section 16(2) factors as being much more positive than negative.
Sorry, this is your third point.
Yes, I've left the pollution point or wrongful influence point. I'm on number 3, which is...
Sorry, this is the other section's 16 factors.
Yes, 16(2) factors. And the central submission is the judge failed to see them as much more positive than negative. And we've seen in paragraph 89 that he saw them as negative. The two central ones are subparagraphs D and E and F. Well, F is an exhaustion of remedies clause. And it was exhausted here, including alimony, as Lady Justice King made clear at the passage we've just looked at. So the fact that she'd exhausted her remedies.
Hold on, apart from you've taken us to 52.3 in the judge's judgment when he says recalls that he was told that the wife did not make any needs-based claim, and you've taken us to 89 in the other section 16 factors. Does the judge anywhere else in his judgment deal separately with F?
Yes, he does deal with this. he deals with them in paragraph 80, which is what I'm coming to now.
Okay, thank you. I see. Yes, you're right. Thank you. Yes,
So I'm just making my general points.
right.
Subparagraph F is an exhaustion of remedies. And it was exhausted here. We say that's in my client's favour, not against. I.e., she'd done all she could to get justice in Russia. Subparagraph D enjoins the court to look at the benefit from the orders in Russia. The judge saw this as a negative, as we would see. We say it's a positive, because if you look at the Russian orders, it shows she got a tiny percentage.
Sorry, wait a minute. Which so something got behind you. Which paragraph are you looking at now?
I was
Which
looking at the
paragraph?
statute, paragraph D in the statute.
D. Thank you.
D in the statute,
Yes, got
which
it.
is you look to what she
Yes,
got.
the financial, but yes, has received, likely to receive, etc. Yes.
D and E is look what she got in Russia or what she might.
Yes.
And I was saying that this shows her getting a tiny percentage, no share of his beneficial entitlement to billions, and of course, no share in the 3 matrimonial homes. Instead, the judge focused on what she'd got, which ignores the injustice, which of course, Lord Collins said in Agbarji was relevant to look at the injustice. And that's paragraph 61 and 72 of Agbarji. Now, I'm now going to turn to what your Lordship highlighted, paragraph 80. He deals with D and that there's been complete compliance with the order. That paragraph ignores the injustice point. It ignores that there's no proper sharing. And therefore, if you look at that subparagraph, we say that's a positive, not a negative. Section 16.2f requires the court to assist the exhaustion of remedies. And Mr. Bishop characterises this as more akin to the 6th bite. Well, what that ignores, and the judge is finding, is that actually the fact that my client had exhausted her remedies was in her favour. If she hadn't tried to get justice, she would have been criticised. And that she did fail to get justice. It really can't be objectively doubted that she failed to get what, from an English point of view, is objective justice. A tiny proportion of this huge amount of money, all made in the marriage, where she brought up 3 children and remained married for a very long time, whoever you believe about the end of the marriage, which again is for the final hearing. Paragraph 82, no property available in England. Well, that's the only factor slightly against her. But she does only claim a lump sum, and the husband has always said in his witness statements that he respects the English court. He litigates in England. The shareholding of the main company is listed on the English Stock Exchange. None of this mentioned by the judge. And obviously I don't want to go into more details because of what that might involve, because I want to keep my powder dry, but you can't ignore the fact that cross-examination may open up avenues. Excuse me. 83 is neutral. 84 is neutral, or not against my client. So we really have 80, 81 and 82. And we say 80 and 81 actually are not negative, they are positive.
So when you say, when you referred us to 89, where the judge said a survey of all the other section 16 matters, counts heavily against the wife, which on his analysis between 80 and 84, which would you say fall into that category?
The only one arguably is 82.
Right.
Because if you look at D and F, they're not negative. I mean, the fact that you've exhausted your remedies and you've still, excuse me, not achieved justice is in your favour. What you got in Russia is relevant to look at. I mean, if my client had got 30% of the beneficial interest, well, F would count against her. But she got nothing. And it doesn't really matter if she made, I mean, she only made one substantive, only a claim in one substantive jurisdiction for matrimonial relief, which was in Russia. She tried very hard. In a sense, the criticism of the husband is that she kept appealing, but she did try very hard. But the end result, and there's no dispute about this, is she only got a very small, tiny percentage of what this husband had made in the marriage. 20 billion or thereabouts. And of course, objectively, my client still having 20 million or whatever it is, it's a lot of money, but it's not anywhere near justice. And as I've said, you could say paragraph 82 was slightly in my client's, not in my client's favour. But I've dealt with what we say about that. But I mean, clearly the judge was not referring to that. He didn't go into that in a lot of detail. And then if you go forward to paragraphs, 89, and do remember in 89, the judge in paragraph 89 is dealing with needs. He's not dealing with sharing. His sharing ruling is paragraph 88, where he doesn't actually put section 16(2)(f) into the balance. When he's dealing with sharing, he decides it's solely on connection. And then when he goes to 89, it's needs. A survey of all the other section 16 factors counts heavily against W. Well, my submission is that is wrong on his finding, and his findings are wrong. And he comes back to it in paragraph 91, where he's still dealing with needs, where he says, I accept that wife could argue that her reasonable needs have not been met. He then goes on. However, the other section 16 factors militate strongly against her claim proceeding. Well, why? Don't say any more. Because he doesn't explain why. That's my third point. Fourth point, I think I've already, but I'll just summarize. We say he failed to put adequately into balance the fact, not allegation, that my client had suffered an injustice. There is no mention anywhere in the judgment of what Lord Collins said about injustice. It's just not mentioned. And that was my client's case. It should have been mentioned and dealt with, if only to say why he wasn't influenced, but it's not there. In the judgment, in page 211, again we say a very confusing paragraph.
Sorry, tell me again.
Page 50, sorry, page 211, paragraph 54.
Thank you. Yes.
I had more particularly in mind whether H has suffered injustice and or hardship. Well, he didn't really come back to specifically mention injustice, though quite clearly earlier he had thought there was an injustice in the judgment at 192. And what he says in 216.
Sorry, page 192.
216, I'm sorry. 216, paragraph 85, which we looked at. He describes it as a paltry award. Well, that of course is in line.
Where does he describe it as a paltry award?
In the second line at
That's
paragraph 85, 216. English standards of paltry award. That's really the only reference to the injustice. And paltry, of course, resonates with top-up disparity. It's not paltry lack of generosity. It's objectively unjust. And paragraph 88, as I've said, is his roundup paragraph about injustice, and there's no mention of it. The only other mention of injustice is in paragraph 92 on page 217, which again we submit as a rather remarkable observation, simply because wife has suffered what she regards as a very significant injustice. Well, why qualify it like that? I mean, on any view, having decided that she was an entitled wife and not quibbling with the fact that everything was made in the marriage, why did he? It just shows that he didn't properly consider injustice. The next point, which is related to that, I think is point 5, failure to deal with the lacuna point properly and or see that there was no comity problems, as of course Mr. Justice Cohen thought in his observations in paragraph 90 at 217. The respondents team now seem to be saying that my client lost because there was a finding in Russia that these beneficially owned assets were not matrimonial, as opposed to a lack of power, and therefore there's a comity problem. But actually, in the past, it has been said that there was a lack of power in Russia, and the reference to that is supplemental bundle, page 65. The way it is put now is...
Sorry, supplemental bundle, page 65.
It said a lack of power.
What is that document?
I think it's a skeleton argument. I hope I got the right reference. Yes, it's the skeleton for January, for June 2019, and it's paragraph 60B.
60.
B. Or alternatively, they lack such a power.
That was the case that was being advanced on your behalf.
Yes, but there's no, you're
Is
right in the law, but there's no quibbling about it at that stage.
And that's just setting out the two ways in which it was being advanced on your behalf. One, that the court did have power, but didn't because of influence.
But it's not a criticism, that it was a power point.
Right.
And the way it is now put is page 69 of the core bundle. Paragraph 60. And we say that is the proposition in italics is quite wrong. It wasn't that they were held not to be matrimonial, that there was no power. And what the footnote reference is to the description by Lord Legate at 16. Well, of course, Lord Legate did not see, because they weren't in the bundle, the Russian judgments. But if we go forward to what he said, we don't say that the footnote justifies what is suggested. And if you go forward to page 261, you will see in paragraph 16 what he said. I mean, all he said is in the second sentence, for this purpose, however, only assets legally owned by one or both parties were included. But of course, as I say, he hadn't looked at the judgments, but he is not saying there that there was a finding in Russia that these assets were not matrimonial. It's never been suggested that Russia approached this case like we would approach it, by either saying that they were pre or post-marital or inherited. The clear inference is that it wasn't permissible to include. If you would then go back to page 204, which is in paragraph 28, this is Mr. Justice Cohen's judgment. What he said, and of course he did read the judgments, in the last sentence of paragraph 28, it was not permissible to divide any property. Well, that clearly is not referring to an assessment, it's referring to power. And we say the case is clearly established that the Russian court repeatedly, my client went on trying, clearly established that they found that they had no power to deal with assets that were beneficial to the owner. And it's always been our case. But even if there's a finding, which I don't accept, that these were not matrimonial, the Singapore Court of Appeal case, which is in the authorities bundle, is illustrative of an approach by that court that there are really no comity objections. And the Singapore case, which is at page 595 of the bundle, but I can give the core point very simply. In the Singapore court, there was a matrimonial finance division. One asset was held not to be a matrimonial asset, which was a London property, which was the most valuable property, which was therefore not divided in Singapore. So the wife, who had come here, made a Part 3 claim about this asset. The husband then sought in Singapore an anti-suit injunction. He said, Singapore has dealt with it, not matrimonial, therefore you shouldn't be going in London. The Singapore Court of Appeal, in a lengthy judgment, reasoned, decided not, that there was not a comity point, and this was not relitigating the same point. So we say that there isn't a comity point here. And the lacuna, I want to deal, I hope, by headings, why we say this is relevant. It's relevant as to why there was an injustice, why there is unfairness objectively, and why the points in Agbaji about no adequate provision apply here, and the court should be applying objective English standards. It shows that my client was not seeking a top-up to achieve generosity or to just go to what an English award would be on an assessment. She wasn't saying, for instance, they gave me too small a house, or they didn't give me 2 houses. She was saying that it was wrong in principle and unjust from an English point of view. And it wasn't a mere disparity. It wasn't a mere disparity, it was about 1%. It's not a mere disparity. My client does not have to attack a Russian assessment or a judicial discretion in Russia because that didn't occur. So there's no comity problem, you could say. And we've dealt with that in paragraph 75 to 76 of our skeleton. And it's not as though we are asking the English court to plug a hole in Russia, in Russia's domestic court. We are asking a court in England to conclude that what happened in Russia was objectively unfair according to English standards, which is appropriate because my client is now living here. And of course, a court under the statute can make a second order. And therefore, we are asking the court in England to address the fact that the Russian approach on the facts of this case and the developments has led to a very considerable injustice. And finally, on why it's relevant, there's no comity problem, as there are many lacuna cases, including Agbaji itself in English courts, and we deal with those in paragraph 77 to 78 of our skeleton argument. And why Mr. Justice Cohen fell into error and was inconsistent, the following reasons. I've already said that he was addressed about AA and BD and he didn't come back to it. And he dealt with the injustice in his judgment, paragraphs 4 and 7. I've already made the point he purported not to understand AA and BB, and then he doesn't mention it subsequently. And I dealt with quite clearly why Lady Justice King thought this was important. It's paragraph, page 239, paragraphs 53 to 55, 243, 244, paragraph 74 and 75, which is where she said there should be an analysis, and paragraph 82 at 246. That's all I want to say about that point. The next point, which I think is my 6th point.
Yes.
I mean, I have touched this already. I can deal with it very quickly. We say the judge failed to approach the case on the basis that my client's evidence was correct. And on that basis, if you assume that, she sails past on the reverse summary judgments test. Unless it was completely wrong, and there was no reason to assert that she was wrong, then he should have proceeded on her factual basis. Instead, he made findings which were unjustified and without oral evidence. And I rely on what Lady Justice King said at paragraph 87 on page 247. And there were many findings she made, and I think I have identified them. Divorce tourism, the significance of seeing the solicitor, modest connection here, the suggestions about Oyster Bay as opposed to the small flat, the position about, the position about, yes, the Russian court did not deal with alimony. And it goes further than that. You say, because if you look at what Lord Leggett said at 285, which I would like to look at briefly, because paragraph 92 we've looked at already, and I rely on that. But I also rely on Lord Leggett giving great commendation to what Lord Hope said in the Three Rivers case. And we say that if you approach this case on the basis of what Lord Hope said, really there's very little doubt my client should, and this decision was available at the time, should surmount the hurdle. If you go to 285 at the top, Lord Hope postulates a matter of law that means that my client would not succeed. Well, there's no reason to think that there is such a matter. In other cases, it may be possible to say with confidence before trial that the factual basis for the claim is fanciful because it's entirely without substance. Well, that doesn't apply here. It may be clear beyond question the statement of facts is contradicted by all the documents or other material on which it's based. Well, that doesn't apply here. And then the simpler the case, the easier it is likely to take that view and resort to what is properly called summary judgment. But more complex cases, of which this is one, are unlikely to be capable of being resolved in this way. And then Lord Leggett goes on, applying this approach to applications for leave, and then he makes his observations. I think that is my 6th point, if I can add up. I now wanted to deal with needs, which of course...
Are you coming back to the test?
That was my last point. Would you like me to deal with that now?
No.
I hope I've got 20 minutes. Needs. What we say, in reality, the learned judge made findings which made leave on needs overwhelming. And the point that was against granting leave was unsubstantiated. The overview is as follows. The starting point is that there was no needs award possible. And that's Lady Justice King, page 231, 244. Therefore, there was an objective injustice given that my client had no share of any of the matrimonial homes, and she had a huge standard of living. And that really is part of the findings we say that the learned judge neglected to make, which he could have made. He didn't make it. The three matrimonial homes were extremely large. Large flat in Moscow, the Autumn House, purchased or built for $150 million, and then the Forest House, which was on the complex at Luksky. I hope I pronounced it correctly. My client was left with no share in any of them. She was left with the pretty desultory property, most of which is frozen, which is set out at S291. The husband did not deny in his witness statement that he was the ultimate beneficial owner of the Autumn House, which my client said was in the name of a nominee who had not got the money to buy it. But he didn't deny that. So that is all relevant to, we say, needs. Then, of course, there is the observation, because there was no needs award possible in Russia, we don't have a comedy problem. Lord Collins, at page 73 in the authorities bundle, paragraph, page 106, said,
Sorry, paragraph
106, it's where he said one of the goals, page 106.
Page 106
In the authorities bundle.
Paragraph 106.
Paragraph 73, page 106.
Sorry.
I hope I got it right, I'll check it. It's between B and C.
Paragraph 76.
73, page 106, paragraph 73. Third, where possible, the order should have the result that provision is made for the reasonable needs of each spouse. Well, reasonable means, in the context of English law, of the standard of living and the resources. And what my client got, as the judge acknowledged, did not fit that criteria. So let's look at what Mr. Justice Cohen said about this. Well, in the argument on the 19th of January, he said that my client had a very strong case on the needs argument. And we refer to that at core bundle 83. Which comes from the transcript.
Sorry, wait a minute. This is core bundle paragraph 83.
Page 83, paragraph 23. This is our original skeleton argument for the Court of Appeal. And in paragraph 23, 4 lines up from the bottom, during the hearing, Mr. Justice Cohen referred to W having a very strong case on the needs argument. And you can see there's a footnote reference.
That's the initial hearing.
The initial hearing.
Yes, okay.
But again, on inconsistency, we say there's no reason to change. I mean, because the husband, as I've already told you, didn't say anything about my client setting out her needs. Then when we get to the judgment on needs, 210,
Yes,
obviously I've already referred
it's 2,
to
3.
subparagraph
Yes,
3.
you have.
I won't do that again. 216, paragraph 85, which we've looked at, where effectively he says, again, my client has got the last sentence. Further, the award that W has received would probably not, in an English case, based on these facts, be likely to meet her reasonable needs. So that's obviously, I can rely on that. And then we get page 217, the paragraphs we've already looked at. He deals with needs between 89 and 91. So he accepts that she would achieve a better standard of living, one to which she could easily argue she's entitled. And then he deals with the comedy point, and I've already said there is no comedy point. And then effectively, he says, well, although she hasn't got her reasonable needs, the other section 16.2 factors count against her, and I've already dealt with how that is unfair. And not only do I ask you to bear in mind that my client got no share in any of the three main matrimonial homes, she got none of the art, which she said was worth millions, and she got no part of the Autumn House, where she lived from 2017 to 2013, which was built.
Sorry, that doesn't work. 2007
to 2013.
Thank you.
Which was built, purpose-built for the two of them at a cost, including the garden, of 150 million American dollars. And not mentioned at all in the judgment. So that influences her housing needs. And we say that they have not. And in any event, my client was not given any opportunity to answer any point put about her needs. But in fact, the husband did not challenge her needs at all. And if one looks, he dealt with, to some extent, the needs at supplemental bundle 138.
One, 3, 8.
Sorry, I've opened an old one. I am sorry. Starts at 137. This was put in October. It was an appendix concerning limitation of leave.
Right.
And it was, for some reason, not put in the main skeleton, but it made the skeleton about 54 pages, but it just dealt with whether there should be limited leave on needs. So here was the opportunity to say, well, she's got all her needs. 41 million is enough, or whatever, or 7. But it's not what is said. 38C, there's a legal point made. We don't accept the PRISM as the foreign court. The PRISM is it objectively adequate financial provision? You don't ignore the foreign court, but you certainly apply English standards. And you can see what was said at 139, paragraph 9. Instead of dealing with needs, or what he said about needs, Mr. Bishop goes back to the point. We suggest that allowing even a limited leave to the party who obtained the leave in an ex-party hearing through gross misrepresentation would constitute a grave injustice. So we're back really to the wrongful influence point. He was saying, forget the needs because she's in such gross misrepresentation. But this was the opportunity to say something about the needs. It was not taken up. And we say there can be no doubt. That leads me to my final point, which is the test. I think this is my 8th point.
It is your 8th point, but I've got 9 messages anyway.
Good, and I can add up. This is the test.
Yes.
My point is the threshold is now easier to overcome, and the wife comfortably passes it. And looking at the judgment, there was no reason to conclude that she could not pass. Now, we really can look at this all through Lord Legate's judgment.
Can we first of all look at the judgment? How do we glean from the judgment the test that was being applied by Mr. Justice Cohen?
Well, 93 says no solid basis.
Right. So he was applying
the solid
the
basis.
solid Agbaji basis.
Yes.
Thank you.
I don't think there's anything else because he set out paragraph. I'm not sure he sets out paragraph 30. I'll be corrected if I. What? What paragraph? Paragraph what? 62. 60 what? 62. 62. Sorry, I'm getting it close. Yes. Paragraph 62, he sets out the
So no, and no solid. So it's the same.
no
Yeah.
Is there a substantial ground which means solid? But he doesn't set
Sorry,
out.
62 is just the
60 is section.
It's the statute.
it's just
Yeah.
the statute.
It's the statute.
61 he refers to
Well, that's knockout blow.
knockout blow, and then but then he says no solid ground for bringing an application. So he refers again to solid.
It's
Thank
really
you.
all solid.
So he we can
doesn't
take
mean-
it that he was applying Agbargi.
He doesn't really deal with paragraph 33 of Agbargi, which I'm now going to turn.
Right.
He doesn't deal with it at all. And so, and of course, we say things have moved on as a result of the Supreme Court, which is what I'm coming to. And we can look at this all through the prism of what Lord.
But first of all, we go to paragraph 33 of Agbargi.
Well, it is actually quoted by Lord Legate.
Oh, okay. So we're going to the Supreme Court judgment.
Yes,
Yep.
because you don't need to.
Thank you. Which page?
283.
Yes.
86.
Thank you. So that's Lord Collins.
Lord Collins is quoted there, and the point is that the quote, it's the principal object, it's not the threshold test. The principal object is to prevent wholly unmeritorious claims being pursued. And that has been clarified as not being the test, but my submission would be it was never the test. The test is the next sentence. The threshold is not high, but is higher than serious issue to be tried or good arguable case found in other contexts. It's perhaps best expressed by saying that in this context, substantial means solid. And then paragraph 87, Lord Falk's observation that there's an internal inconsistency is dealt with. And then paragraph 88, there is a discussion about serious issue to be tried. And the important point is that Lord Legate says the serious issue to be tried is exactly the same as the summary judgment test, real prospect of success. So applying that to what Lord Collins said, you could equate in paragraph 33, serious issue to be tried as real prospect of success. Then paragraph 89, there's a discussion where clarification is needed. And really where effectively Lord Legate says the closest analogy seems to be with other contexts in which a court has to decide whether a claim should be allowed to proceed, which is real prospect of success.
Yes.
So if you've got to have an analogy, it's real prospect of success.
Yes.
I mean, he rather goes further later on. The significant thing is in paragraph 90, good arguable case is not apposite. So that's why we say that the test is now easier, not more difficult. The test is easier because it used to be higher than serious issue to be tried, which is which is a real prospect of success and good arguable case. It's now, if anything, the same as serious issue to be tried, not higher, and good arguable case has gone into the judicial death bench on this.
And then there's the comparison which you took as
Yes,
to-
which I took to you in 91, because then he rather goes further about it really is the reverse summary judgment test. And then he refers with great commendation to Lord Hope, which I've already relied on. And then we end up in paragraph 92. And that really is, we would say, exactly the same as a court's approach on summary judgment. You assume the facts are true unless someone comes up with something to show it's not true, a document. I mean, if my client said she'd never been to Italy or something, and her husband had come up with a manifest, it's things like that. It's not you're wrong because you're a divorce tourist.
And these paragraphs were agreed by the minority.
Yes, exactly. 300. I think it's 300.
Well, I have it on page 290. Paragraph 110, I thought, but maybe I'm looking at the wrong thing.
Yes, you're right, my lord. Yes. Mr. Magpal has pointed out that actually Mr. Justice Cohen does cite paragraph 33 of Agbarji at paragraph 43, which is page 206.
Thank you. Yes, paragraph.
And I did want to rely, sorry, on what Lord Briggs said at 138.
Sorry, 138.
Sorry, 29, paragraph, page 299, paragraph 138. Where he sounded a warning, which we say is apposite here. Even if the set-aside application led to a rehearing of the leave, well-heeled respondents might nevertheless be tempted to allege misleading at the without notice stage, either to find a submission the relief should be denied regardless of the merits, or more simply just to poison the mind of the judge. Say very apposite what happened here. And page 300, 142, paragraph 142, the last sentence. Section 16 makes it clear this assessment must be conducted by reference to matters as they stand at the time of the final hearing, so that any examination of them at the permission stage must, in a case where leave is then given, necessarily be provisional. Which is why we say Mr. Justice Cohen was in error not looking forward with our clients. Was it foreseeable she was going to stay here? And I've already made my point about that.
Are these paragraphs obiter, just as a matter of question, or are they actually part of the?
We say that Lord, the husband did challenge the test.
Yes.
He said you've got to change.
But why was the test relevant to the Supreme Court's decision? I mean, nobody's suggesting we shouldn't follow it. I just wondered, just a matter of interest.
It was relevant because I think there was a suggestion that we were relying on, that we got past because we were not wholly unmeritorious.
Okay. Anyway, they all agree that the
we're in reverse.
that the paragraph 33 needs to be clarified, and it's been clarified in the way set out in Lord Lennox's judgment. Yes, thank you.
To draw the threads together in this, if Mr. Justice Cohen had done 4 things which he failed to do, we would say my client would pass comfortably the summary judgment test. 1, assume my client was right and might be right. 2, not.
Sorry, wait a minute. By right, you mean right in
Correct.
her factual assertions?
Assume my client was right factually and might be right on factual matters which were alleged but not considered, like the Autumn House. 2, not approach the case on the husband's factual matrix, which he did, and which was unfair because no opportunity to answer. And I've already referred to paragraph 59 at 212 and his reason for not giving position. At 221. Thirdly, if he'd applied the reverse summary judgment test. And fourthly, as he was enjoined to do.
Hold on.
Sorry, my lord. It's just I'm obviously 2 minutes past my
Yeah, but that it doesn't.
I'll slow down.
Thank you. If he had applied the reverse summary judgment test, he would have granted leave. Is that what you're saying? Yes.
And fourthly, if he'd looked forward to the trial on connection. And what and that is paragraph 92 in the Supreme Court. And the conclusion that I wanted finally to look at the last sentence of Agbaji at page 107 in the authorities bundle.
The very, very last sentence.
Yes. Maybe. It's about 4 lines up. It was not so much that there was a very large disparity, which is like top-up, between what the wife received in Nigeria and what she would have received in England, but that there was also a very large disparity between what the husband received and what the wife received, such as to create real hardship and a serious injustice. Sums up this case. What the husband was left with was 99% of 20 billion. One could hardly envisage a greater injustice. There was no basis for interference. That's really the way we've always put our case. Sorry, it's 4 minutes over. Unless there's anything.
No, thank you. Thank you. Yes, Mr. Nagpal.
May it please the court. As the court will be aware, our primary overarching submission in relation to ground 12 is that the judge misconstrued section 16(3) of the 1984 Act, and had he interpreted it correctly, he could not, and thus should not, have dismissed that part of the wife's application that related to maintenance in the autonomous European sense of that term, i.e. needs-based, under section 16, which is in fact what the judge did. Our alternative overarching submission is that even if the judge's construction were correct, then the judge was nevertheless wrong to have dismissed the wife's maintenance application under section 16. We submit that a proper and fair assessment of those factors in section 16, which the judge found that he could take into account, do not support the judge's conclusion. I was not proposing to say anything more on the alternative second submission, except that in writing, and of course yes. Mr. Howard has dealt with that this morning as well. So, before developing our overarching primary submission, there are happily some points of common ground between the parties in relation to ground 12, which I thought it might be helpful if I briefly set them out. But just before I do that, may I check that the court has received the joint letter to the court at Bundle D? I'm grateful.
Yes, thank you.
By my count, there are 7 points of common ground, which I can deal with very quickly. The first is, it is now agreed that section 16(3) does apply in this case. As the court will have gathered from that letter, the husband had sought to put this point in issue in the original appeal in his respondent's notice through the different ground, but subject to the approval of the court, that issue has now fallen away. The second and third points of common ground are set out verbatim in that letter, which I can just ask the court to turn that up. It's at core section D 372, and it is the second and third points are the first 2 numbered points in that letter. That section 16. Yes. Yeah, you've got those points, and obviously 2 is the converse of 1. So yes. Those are my first 2, second and third points. The fourth point is that it is agreed that the wife satisfied the jurisdictional requirements of Article 3B of the maintenance regulation imported into the 1984 Act by virtue of section 15(1) capital A, namely her habitual residence in England and Wales. Fifthly, it is agreed that the term maintenance creditor used in the maintenance regulation does indeed apply to first-time applicants. Lord Leggett had raised the question in his judgment in paragraph 101, although before that. 6. The underlying policies of the maintenance regulation, which we have set out at paragraphs 95 and 96 of our skeleton, are also agreed. See paragraph 81 of the husband's skeleton. And finally, it is agreed between the parties that the wife must still obtain leave and thus must satisfy Section 13 to pursue her needs claim, but what that entails and whether she does in fact do so are not agreed. Turning then, if I may, to our primary overarching submission that the judge's construction is wrong. As the court will recall, both parties advanced rival interpretations of Section 16.3. The judge rejected both interpretations and formulated his own. The judge's construction is at paragraph 79 of his judgment. If I can just invite the court to turn that up, which is at page 215 of Paul.
Yes.
He says, in my judgment, the effect of Section 16.3 is to disentitle a judge from dismissing a claim by an applicant for maintenance solely on the basis of the absence of connection of such applicant. It would not be inconsistent to dismiss a claim, if appropriate, on grounds relating to matters other than the habitual residence stroke connection of the applicant with England and Wales, but in applying Section 2 factors, I must give weight to her habitual residence. We submit that the judge's construction is clearly wrong, in essence, for two reasons. The first reason is that it is just not what Section 16.3 says. If perhaps we can go to Section 16.3, which is in Authorities bundle, tab 32, page 927, as it's in front of it.
Yes.
Section 16.3 prevents a dismissal on the ground in Section 16.1. It does not refer to connection or absence of connection, or even Section 16's 2A to C. There is only one ground of dismissal under Section 16, which is that the court is not satisfied that it would be appropriate for an order to be made by a court in England and Wales. And Section 16.3 refers to Section 16.1, i.e. to that single ground. Section 16.2, on the other hand, merely contains a list of non-exhaustive factors, as confirmed by Lord Collins at paragraph 44 of Agbarji. And we submit that the effect of Section 16.3, as regards this case, is clear. If the judge was effectively saying, well, I'm allowed to take into account the other factors, but not Section 16's 2A to C, that is not what Section 16.3 says. The second reason we rely on is that the judge's construction is antithetical to the operation and underlying objectives and policies of the maintenance regulation. We know from the authorities, and I don't think any of this is in dispute, that whether it be Villiers, R&P, Sanderson, Hoover, and we've set out the various relevant paragraph references, paragraphs 94 to 95 of our skeleton, we know that in matters of maintenance, the maintenance regulation provides a series of mandatory, exhaustive, and predictable set of rules of jurisdiction. And it is the maintenance regulation alone that determines whether a member state has or does not have jurisdiction, and also whether a member state can or cannot exercise that jurisdiction. But for Section 16.3, Section 16.1 would empower the English court to decline to exercise jurisdiction by dismissing the application on the basis of lack of appropriateness of the English court to make an order. And of course, it makes that decision by taking into account all the circumstances of the case rather than a fixed rules-based approach. Thus, we submit that it is completely at odds with the system set out under the maintenance regulation and the underlying reasoning of Owusu, R&P, and Villiers. Now, learned friends are seeking to draw a distinction between, on the one hand, forum non-conveniens, FNC, which they accept is inconsistent with the regulation, and on the other hand, Section 16. But we submit this supposed distinction completely misses the point. Whilst the cases that I've just referred to were all dealing with forum non-conveniens, what is critical, we submit, for present purposes, is the underlying reasoning of why the principle of forum non-conveniens was held to be inconsistent with the Brussels regime and also the maintenance regulation. And the answer is that because FNC was held to be an impermissible derogation from the mandatory and predictable rules of jurisdiction, said to be a discretionary power, and it matters not for these purposes whether it's properly characterised as discretionary or evaluative, but it's a discretionary stroke evaluative power which is inconsistent with the operation of the fixed rules-based regime of Brussels. This is a fortiori in relation to the maintenance regulation for two reasons. First, the jurisdictional rules of the maintenance regulation are exhaustive. There's a prohibition on reference to national law for jurisdictional issues, set out in recital 15. And secondly, a key element of the maintenance regulation is the special position of maintenance creditors and the fact that they have the option of deciding whether to bring their claim, providing they satisfy the jurisdictional requirements of the maintenance regulation. Now, given the time available, I wasn't proposing to take the court through the relevant passages of the authorities that address that underlying rationale of the FNC, of why FNC is incompatible, and we submit by parity of reasoning applied to section 16. But if I can give the court the specific references, they can all be found in Lord Sale's judgment in Villiers, paragraph 28 of that judgment. And then in that paragraph, I think his lordship refers to Owusu and cites passages. And the particularly relevant passages for Owusu are 40, 41, and 43. There's also paragraph 29 of Villiers, again Lord Sale's judgment, and then paragraph 32 of Villiers, and also paragraph 42 of R&P, which is cited by Lord Sales in paragraph 32 of Villiers, and finally paragraph 34. Those references, I hope,
Of Villiers.
Of Villiers, of Lord Sales, and of course the points that we've been are actually they're unanimous. So Lord Wilson also agreed with the incompatibility of FNC, but those paragraphs in particular show why it is that FNC is incompatible. So that we say that the reasoning applies by parity of logic.
Can you remind me, are those references in your skeleton? Or...
They are all in the skeleton because we've given more references to Villiers where we get outside of the history, but those are the particular ones that are that have pinpointed those references, as it were. In our submission, quite simply, section 16 suffers from the same vice as the power to stay on the basis of formal inconvenience, and the fact that section 16(1) and formal non-convenience don't involve identical questions we submit is irrelevant. In FNC, the question is there another forum that's more appropriate? In section 16, is England an appropriate forum?
Sorry, can I just understand? Are you therefore saying the effect of your submission is that the judge is bound to grant leave?
If you can get over section 13, which is that the judge still has to conduct, on a reverse summary judgment basis, a merits assessment of the needs claim. So you do have to look at the merits, but you can't dismiss on the basis of section 16. We do say that. Which is
So
what
you
did.
say effectively sections for present purposes, you say section 16 is disapplied.
Is effectively. As I say, you still have to get through the merits threshold. And we submit that section 16(1) undermines the certainty, predictability, and protection afforded by the regulation.
If you say that the court still has to decide whether there is substantial grounds for the making of an application for such an order, then how does your submission fit in with that? The court can still take into account, when deciding whether or not there's substantial ground, the matters set out in section 16(2).
No. Well, it can look at section 18, of course, and there is always some overlap between the circumstances of the case, section 16, section 18. But as was highlighted by Agbaji, section 16 and section 18 are doing different things.
I understand that, but if when deciding whether or not there is substantial ground, are you submitting the court is not entitled, for some reason, to have regard to the matter set out in 16(2)?
Well, if insofar as they are relevant to the underlying merits of the needs claim,
Yes.
then yes, of course.
But does connection not have
Well,
some relevance to the underlying merits of the needs claim?
It's difficult to see why it should, because
So it's a question of understanding what you mean by the underlying merits of the needs claim. You mean look at what this wife has got.
What's got.
No territorial or jurisdictional points
well,
at all.
of course, look at what the wife's got. You look at the totality of the resources. You look at the circumstances now of the case. Now, if in a case where there are the wealth was much lower and the wife had got a very substantial needs-based award, the court can of course say, well, I'm sorry, I'm not going to grant Eve leave because that's what I mean by the underlying merits, the Section 18 test. Of course, the court can apply the Section 18 test, and there is an overlap of certain factors. So what she got in Russia is, of course, a relevant assessment. But on a needs assessment, it's difficult to see why, on a connection issue, why that should be, she gets less on a needs assessment. The sliding scale, because it comes back to what Lord Collins said in Bargy, paragraph 73, the minimum award is reasonable needs. And so the sliding scale operates between reasonable needs and a top-up, i.e. an award that would have been made under the MCA. And so, of course, in Section 18, you're going to consider those.
Yes.
But for a needs-based award, we submit she gets the reasonable needs. And
yes, but no, that's not very helpful, is it? The authorities, I thought, told us that in assessing a needs claim, you take into account the Section 16(2) factors, and one of them is connections. So just because you're through the gateway, you've been given leave, the needs assessment is not conducted in the same way, putting it, a purely English divorce needs claim would be assessed.
that is the view, I think, of Mr. Justice Moore when he talks about a lower assessment of needs. I'm not sure, well, I'll be correct if I'm wrong, that any other judge has taken that view, and it's certainly not what Lord Collins says. He talks about the reasonable needs. And so...
He does, but in the reasonable needs in the context. And he also refers to connections.
He doesn't say that. All he says is reasonable needs. That should be met. And we would say, applying the Lex 4I, applying English law, reasonable needs are reasonable needs. I mean, of course, you're going to look at the circumstances. But what the judge can't do, in my submission, is what this judge did do expressly is he dismissed on the basis of Section 16. And so, that, I do say, he wasn't allowed to do.
So your submission... the submissions are advanced on behalf of the wife at the final hearing, if this goes to a final hearing, would be that her reasonable needs should be assessed in the same way that a purely English divorce.
Well, that would be certainly my primary submission. I mean, I imagine, absolutely. Well, right. Obviously, our primary cases, as you know, we should be getting a fair share of the...
I understand that, but we're talking about needs.
I think that would certainly be our primary submission. But whether I'm right or wrong about that, as I say, that's a matter for trial.
One thing you're going to have to address is in subparagraph 3 of Section 16. It says...
Unless inconsistent.
Yes.
I'm coming to that.
Okay.
I will come to that. And so, but as I say, what he did and why the judge's decision can't stand, subject to the point that my Lord has just raised with me, is that he did dismiss on Section 16(1). And so his decision on that, in that regard alone, should be set aside. And on the merits point, I rely on the points that Mr. Howard made earlier about the references that he took you to in Mr. Justice Cohen's judgment about needs and her arguability of that claim. And in addition, we also rely on paragraph 16 of Lady Justice King's judgment. I'll give you the reference in a moment. It's a core 231, where again she talks about the arguability of the needs case. So my point is that on the merits, on the underlying merits, as it were, as opposed to whether England is an appropriate venue, we comfortably, if you take into account the judge's comments and indeed her ladyship's comments, we comfortably cross the summary just judgment threshold. So I'm not saying that leave doesn't apply, but I'm saying we satisfy it.
Sorry, say it again.
I'm saying that she comfortably crosses on the needs assessed question,
right,
the reverse summary judgment threshold. So I'm not saying that she doesn't need leave. I've always accepted that we need to go through the filter, but I do say that the court can't say in the filter, well, she's not going to satisfy Section 16, therefore I'm not going to give her leave.
Right, okay.
Mr. Dover, would you be able to just explain whether the reference to the maintenance regulations in Section 15(1)(a)
Yes.
is doing something different?
Yes, it is. I'm just coming to that. I'm literally coming to that. If I may just, in a moment, I'm just coming to it. But could I just say that I have noticed a typographical omission in our skeleton, footnote 32. which is at page 47, it says there, section 16.3 was introduced by paragraph 10.
Yes.
Obviously, it should say paragraph 10 of Schedule 7 to the civil jurisdiction. I'm sorry about that. The words of Schedule 7.
Right.
Sorry about that. Now, my learned friend takes 3 points against us, none of which we submit properly analysed the system. The first point, they say, is that the regulation only applies to jurisdiction, and they say section 16 is not about jurisdiction. Our response is that whilst we of course accept that the maintenance regulation applies only to jurisdiction, the maintenance regulation governs not simply the existence of jurisdiction, but also the exercise of jurisdiction. Now, the exercise of jurisdiction is obviously an entirely separate question from how the court ultimately exercises its powers, whether it makes case management orders, whether it ultimately makes an order on the merits, whether it ultimately dismisses the application on the merits. Essentially, the exercise of the jurisdiction is about whether the court's going to hear the case. And the point that the regulation governs not just the existence, but also the exercise of jurisdiction is illustrated in 2 ways. First, there are the lis pendens provisions, which will be very familiar to the court, which contemplate that 2 member states may well have concurrent jurisdiction, but it's the regulation that decides which member state will exercise that jurisdiction. The second illustration is the exclusion of the power to stay on the grounds of FNC, irrespective of whether or not there is another member of state involved. That exclusion means that the court cannot decline or refuse to exercise jurisdiction when it has it. Applying that to part 3, and this comes back to directly to the point that my Lord Justice Cobb was raising with me, section 15 confers the existence of jurisdiction, while section 16 concerns the exercise of jurisdiction, and that is why both section 15.1a and section 16.3 were necessary. 15.1a telling you when you have jurisdiction, section 16.3 saying you can't refuse to exercise it if you satisfy the jurisdiction requirements in section 15.1a. The second point that is taken against us is that my learned friends repeatedly say that seek to characterise section 16 as a rule of substantive domestic law. Our response is that whilst both form non-convenience and section 16 are principles of domestic law, neither we submit can properly be classified as substantive law. Neither of those powers confers or defines legal rights, duties, or obligations. Rather, they both entitle the court to refuse to exercise jurisdiction that it has. They are essentially the same type of law. Their object and effect is very similar, even if their sources are different. And if the exclusion of FNC is within the reach of the regulation, as it plainly is because it's inconsistent with it, then so too we submit to section 16.1. Incidentally, I think my learned friends even describe section 13 as a rule of substantive law. Probably doesn't matter much for our purposes, but we submit that section 13 isn't substantive either. It's a requirement of leave, which is paradigmatically adjectival or procedural. The third point, which is the point that my Lord Justice Moylan was raised with me, which relates to the last clause. So as we understand my learned friend's argument, they contend that we are not giving due weight to those words, and they say our argument renders the leave filter redundant. Now, as is clear from the explanatory memorandum, those words were introduced after consultees pointed to a difficulty with the proposed amendment of section 16, although we're not actually told what the difficulty was. But in any event, we make 4 points in response to my learned friend's point, the last 2 of which may require some elaboration. The first is that, as I've already accepted, she does still need to satisfy section 13, but we say that section 16 should not play a part of that, because that is a different question. And so the leave filter is not rendered redundant. Our second point in response is that the court does not have to decide in this case whether there might be any circumstances in which the court could dismiss an application under section 16 without it being inconsistent with the maintenance regulation. All it has to decide in this case is whether this type of case, in this application, whether in this case it would be inconsistent. And we submit that for all the reasons about the underlying policies of the maintenance regulation and the incompatibility of a discretionary stroke evaluative consideration of appropriateness of forum, it is inconsistent. The third point, which I'll elaborate on in a moment, is that given the legislative context and the complexities surrounding the potential operation of the maintenance regulation and the haste with which the amendments were brought into force, we submit that a purposive interpretation of section 16.3 is warranted, and that purposive interpretation leads to the conclusion we say that we are advancing. Our fourth point in response is that there may well have been some very limited, very limited circumstances in which it might have been possible to dismiss a maintenance application under section 16 and for it not to have been inconsistent with the maintenance regulation, but that this case isn't one of those very limited circumstances. I could just elaborate very briefly on the third point. Namely the appropriateness of the purposive interpretation. We know that the 2011 regulations, by which a whole host of amendments were brought into force to make the legislation consistent, were introduced at some haste. This is not in dispute. It's in fact, their friends make this point, and it is confirmed by Lord Wilson in Villiers at paragraphs 118 and 120, and his lordship describes the regulations as an in part and unsatisfactory piece of legislation. Moreover, there were some striking drafting oddities, if I put it that way, created by the 2011 regulations. For instance, we know from Villiers that the drafters inexplicably omitted to include a definition of when a court first seized in an intra-UK case, in intra-UK proceedings, and we see that from paragraphs 117 and 124 from Villiers. But perhaps an even better illustration for present purposes is the jurisdictional provisions that were introduced in Schedule 1 to the Children Act. And if I can just perhaps ask the court to turn that up. It's Authorities Bundle 1008. I'm afraid this is... it starts at 1008, and then it's at the end of paragraph 12.3, or paragraph 14, substitute over the page, and then we see a rule. Now that rule is very similar to section 15.1a of the 1984 Act. Now clearly the purpose of this provision was to confirm that maintenance applications, in the autonomous sense under Schedule 1, have to satisfy the jurisdictional requirements of the maintenance regulation. But given the inclusion of the words if and the word part of such an application, a strictly textualist or literal interpretation of this provision might suggest that it's possible to have a Schedule 1 application that is not a maintenance application, maintenance in the needs-based sense. However, we can't think of a single Schedule 1 order or application that would not constitute maintenance. And so the right approach we submit is to interpret these provisions purposively, bearing in mind that context. And if one does so, it was obviously it was belt and braces what was going on here and in section 16 in 3. So we submit that there is only one answer to this case, that the judge's construction was wrong. The fourth point, the final point, is that there may well have been some very limited circumstances in which it might have been possible to dismiss the claim. I say might because they were never tested, and now, of course, they never will be. But we can conceive of two possible, very limited situations. First, where Article 13.2 of the maintenance regulation applies, it's at Authorities 973. That provision empowers, but does not require, a court second seized to decline jurisdiction if there are pending related actions, and the actions can be consolidated in the court first seized. So an example might be, you have child maintenance proceedings in the court first seized, and a Part 3 application for spousal maintenance in the English court, which is second seized. If those applications are deemed related, which is a separate question, but they might be because their judgments could conflict with each other and they could lead to irreconcilable judgments, it might be possible in that situation for the court to dismiss the maintenance application under section 16 of Part 3 and for it not to be inconsistent with the maintenance regulation. It would be effectively giving effect to a maintenance regulation provision. The second very limited circumstance might be where there has been a maintenance decision in one member state that is recognisable and enforceable under the maintenance regulation, which is then followed by a maintenance application under Part 3, but critically, where there has been no change of circumstance. It is at least arguable that such a claim would be incompatible with the maintenance regulation, and so were the court to dismiss such an application under Section 16, i.e. a fresh maintenance application with no change of circumstances, that might not be inconsistent with the maintenance regulation. That, incidentally, my lord, might be the answer to a query that my lord had in AA and BB about paragraph 67 and 69 about what Lord Collins had in mind at paragraphs 55 to 57 of Agbargi. The lordship had said, I didn't really understand those paragraphs, where he had said, well, this Part 3 is disapplied when you've got an enforceable maintenance decision. And the lordship said, well, I don't see that, because obviously there can be sequential decisions, and the maintenance regulation doesn't fix jurisdiction for all time. The lordship, if I may say so, is obviously right about that. But the answer to that conundrum might be a decision without a change of circumstance, because we haven't burdened you with the annex, with Annex 7, which is the application for a change of circumstance, a modified decision. But interestingly, if one can ever use that word in relation to the maintenance regulation, Annex 7 does require the applicant to specify the change of circumstances. So that might be an example. But none of this applies in our case. And so there is possible effect to those words, if they weren't just belt and braces, which actually may well be the answer. And so we submit that a dismissal was inconsistent with the regulation, and thus the judge's decision should be set aside on that basis alone. And one very final point, just a reference. If I can just give you a reference to Core Bundle, page 181. That is our supplementary skeleton for for the original appeal, which responded to the additional reasons in the respondent's notice. So, I mean, in a sense, I've already dealt with most of the points anyway, but we do also rely on those. I think we had cross-referred that in our skeleton, so that's the reference to that. That's 1 o'clock. Sorry, unless I can assist any further, that was all I was proposing to say.
Right, thank you very much. We'll start again at 2 o'clock.
All right.